Let's plan a robbery. I got a dot on this Glock, ain't no robbing me. These niggas like to comment shit on Instagram pics. See me in public, say hi to me. Boy, I don't get it. Bro hit a lick and I'm with it. Been hanging out the ski mask, I can't fit it. Bro hit a lick and I'm with it. Been hanging out the ski mask, I can't fit it. Let's plan a robbery.
Calling case 2:25 MJ 1494, United States of America versus Eugene Henley Jr. Counsel, please state your appearances for the record.
Come on, folks.
Okay, so Mr. Henley, as you know, we're here today because you've been charged by the United States with a felony through a document called a complaint. What I'm going to do is start by reviewing some of the documents I received from you and your attorney. Then I'll have some questions for you, and then we'll talk about your case a little bit, okay? All right.
Yes, sir.
So, Mr. Targowski, I did receive a financial affidavit, but I understand that you are retained, so I'm just going to just...
No. I am part of the CJA panel and seeking appointment.
Oh, I'm sorry, my mistake.
I believe my client will be retained in private counsel. I've spoken to 2 private attorneys, so I would seek a provisional appointment.
No problem. Okay. Let me review the financial affidavit. This is my mistake. We'll take a step back. Here's what I would say. I do think it's questionable, Mr. Henley, that you qualify for appointment of counsel at no cost. In spite of that, I will appoint Mr. Targowski here today from the CJA panel. Here's what I'm going to say. If it sounds like your plan is to retain counsel,
Yes, sir.
okay. If that doesn't happen, I'm just going to, Mr. Targowski, if you're not replaced by retained counsel in, let's say, 2 weeks, then I'm going to direct you to notify the court. And what I will do is I will require Mr. Henley to pay CJA rates. It's essentially a nominal rate that defendants who can afford to pay appointed counsel. It's basically like $170 an hour, which is far below what Mr. Targowski is worth. But it's something.
75.
All right, there you go. But really, if you have, for defendants who have the means to pay,
Come on, folks.
so, but I'll go ahead with it. Up to 2 weeks will be free on the United States. Okay. Any questions about that?
No, sir.
All right. So the next document I'm going to review, Mr. Henley, is this advisement of defendant's statutory and constitutional rights. I'm holding up my copy of the document. This document describes your rights, Mr. Henley, as a criminal defendant under federal law and the United States Constitution. It looks like you signed this document on the second page. Is that correct?
Yes, sir.
Okay. Before signing the document, did you read it or have it read to you?
Yes, sir.
And do you feel like you understand your rights?
Yes, sir.
Do you have any questions for me about what your rights are?
No, sir. Regarding the documents.
Okay. And if you have questions at any time about your rights, take a break and ask a question. Just let me know, okay?
Yes, sir.
All right. Mr. Tarkowski, do you agree that your client understands his rights?
Yeah.
Okay.
Come on, folks.
All right. So as I said, Mr. Henley, we're here because you've been charged through a document called a complaint. I'm holding up my copy of the complaint, pretty thick document. Have you and your attorney received a copy of this complaint, Mr. Henley?
Yes, sir. Yeah.
Have you had an opportunity to review that with your attorney?
Yes, sir.
Do you have any questions about what the allegations against you are?
No, sir.
Do you understand what the government is accusing you of?
Yes, sir.
Mr. Targowski, do you agree that your client understands the nature of the allegations against him?
Yes, sir.
So, Mr. Henley, if you do have any questions in the future, I know you don't now, but if you have any in the future, you can always ask Mr. Targowski. And he has a copy of this, you have a copy of this, you can review it together, just review it with you at your leisure, okay?
Yes, sir.
All right. Now, Because you are charged by complaint and have not been indicted by a grand jury, you're entitled to something called a preliminary hearing. A preliminary hearing is a hearing at which the government would be required to present evidence to establish probable cause to support the charges against you. It's my understanding that you'd like to go forward and schedule a preliminary hearing. Is that right, Steve?
That's correct. We're not waiting.
So I will schedule a preliminary hearing in this case for April 3rd, 2025 at 11:30 a.m. That'll be in this courtroom before Judge Kaufman. I'm also going to schedule a post-indictment arraignment date for April 8th, 2025 at 11:30 a.m. Also in this courtroom, also before Judge Kaufman. Okay?
PIA is
11:30, April 8th, and then preliminary hearing is April 3rd. Same time, same courtroom, same time. Okay, no worries. I have to do that check. So what I'm going to do now, Mr. Henley, because this is your first appearance in this case before me, I'm going to instruct the government pursuant to a law called the Due Process Protections Act. That's a law specifically designed to protect criminal defendants such as yourself. Therefore, Mr. Butler, Ms. McCabe, pursuant to the Due Process Protections Act and Central District General Order 21-02, the court will order the government to comply with the disclosure obligations under Brady v. Maryland with its progeny, and the court reminds the government of the possible consequences of not doing so. Those include the exclusion of evidence, adverse jury instructions, dismissal of charges, contempt, referral to a disciplinary authority, and sanctions. Does the government understand its obligations and agree to comply?
Yeah, thank you.
Okay, thank you. So I think those are all the preliminary matters, other than moving to the government's notice of request for detention. If I missed anything, let me know. Otherwise, the court is in receipt of a notice of request for detention. Mr. Butler, is the government still moving for detention in this matter? And have the parties reached any agreement on the government's request that should be where?
Only that I believe the defense is going to be asking for continuance of the contested detention hearing.
Okay. Thank you for pointing that out. Mr. Targowski, are you ready to proceed with the detention hearing today, or would you like a continuance?
I'd like a continuance to the 31st, Your Honor. I'm in consultations with more than one retained attorney who has asked me for that. I would schedule it sooner, but I have a trial before Judge Barat on Tuesday. I talked to the government. I think if we set something on or around March 31st, that would give ample time for retained counsel to take over the properly handle detention.
Okay. So what you're contemplating is Monday the 31st. Is that what you'd like to do, Mr. Henley?
Yes, sir.
Okay. Let me see, what is today? I know. Today is the 20th. Oh, it's Thursday.
I think what we do in my availability next week.
Okay. And are we going to have retained counsel to do the 27th?
I'm almost certain of it. I'm spoken to an individual named David Chesnell, who has already communicated with my clients, and I believe that's what his plan is. We retain that individual.
Okay. What if we, okay, so
I can handle the detention hearing if that doesn't happen on the 31st, but in order to accommodate my schedule, it couldn't happen next week.
okay. And the government has no objection to the longer than 5 days.
No, Your Honor.
Okay. Well, so
Given the seriousness of this charge, given that there's probably going to be 20 or 30 sureties, many of them are here, that would have to be interviewed by pretrial services and evaluated, given that my client would probably research whether a property bond could be something he could pursue, given all of those things that really have a proper detention hearing, it may take longer than.
understood. In some sense, I kind of feel like it's your prerogative because Mr. Henry, you will be temporarily detained pending this hearing. That's what we're talking about. Normally, we only continue up to 5 days. You are asking for more than 5 days. Your the one who will be held in custody until this hearing happens. So I kind of feel like if you want extra time, it's up to you. So it's fine with me. It's fine with you, Mr. Henley. You can also move it, sort of, you can send us an email, and if you're able to do it sooner, we can make it sooner. Does that make sense?
Yes, sir.
So we can do it later at your request. It's at your request that we're doing it, so it's fine with me. I actually can't do it on the 31st, so it'll be the duty judge, I think is what